think I'll go ahead and just introduce Elderwerks a little bit while everyone's waiting. So for those who are attending this morning's presentation, welcome. I am Jennifer Prell, the president of Elderwerks Educational Services. Welcome to the Elderwerks Virtual Senior Fair. Hopefully you go to many classes and learn many things. We put this fair together to educate the community members on aging issues and topics, and we hope that you find our 2 days of education informative and helpful. Elderwerks is a not-for-profit organization offering complimentary services to seniors, older adults, and families looking for senior living, care, support, and benefits. We act like senior guidance counselors, so you can call us for anything. I'll put our number in the chat box in a second. I'm going to go ahead and introduce Jonathan in about 1 more minute. In the meantime, Elderwerks can help find any type of senior living, such as assisted living, memory care, sheltered care, supportive living, skilled nursing facilities, home care, and then benefits like veterans benefits or information on Medicare, Medicaid, government programming, nutritional projects, transportation, anything like that. So if you do need assistance, please reach out to Elderwerks and one of the consultants will help you. And it is a free service to any senior in need. So with that, I'm going ahead and to introduce Jonathan Thornton from Bruning and Associates. Jonathan is an attorney and he dedicates his legal practice to estate planning, probate law, business law, commercial litigation, and all areas of family law. He strongly advocates on behalf of his clients in order to provide the best possible resolution for each individual's circumstances. Whether preparing a trust or discussing a family law case, Jonathan takes pride in providing intelligent legal advice to his clients in clear and understandable terms. Welcome, Jonathan.
Thanks, Jennifer. Okay, so thank you everybody for being here today. I'm going to start my presentation. I've done a few of these. This is my first one that I'll be doing electronically, so please bear with me. Okay. Thank you for that introduction. Just for a little bit further introduction, I did grow up in the area. I went to Cary Grove High School, the University of Illinois, and then went to law school at the University of Notre Dame. I do live locally here with my family. My wife Caitlin. I have my boy Tommy, who's 4. My son Everett, who will be 3 in 2 days, and then we had a baby girl Blair about 4 weeks ago. So that's a little bit about me. What I would like to do today is discuss with you generally a brief overview of estate planning and then some local updates, or excuse me, current updates about what's been going on this year and some changes to be aware of. So generally what estate planning is the process for planning future events by putting your wishes and intentions, making your intentions known. Planning for disability, planning for the death and distribution of your assets, and planning for the protection of your family, spouse, children, family, friends, etc. It's making yourself prepared. So generally, and again, these are all general rules, what happens if you do not create an estate plan is that there's court. There's a significant chance that the probate court will have a large say of what happens to your health and your assets both during your lifetime and afterwards, including potentially appointing a guardian for any minor children that you might have in certain circumstances. Oftentimes people who are put in charge by the state of Illinois would not be the ones that you would choose, as Illinois has a plan for you if you do not. Assets can often end up with people that you do not want to or do not expect them to, and assets can be distributed to children before you might deem them old enough to be ready to handle such an inheritance. You also lose additional opportunities, such as opportunities to save on taxes and protect your assets. You also lose privacy. All of these things are public, and family disputes are more likely if you do have a probate case open, and there, of course, are unnecessary expenditures of money to attorneys, courts, and the government. So what an estate plan includes, generally again, is a power of attorney for healthcare, power of attorney for property, a HIPAA authorization, I will briefly touch on all of these, a will, and a trust. There are many different types of trusts: revocable trusts, irrevocable trusts, ILITs, Medicaid Asset Protection Trust, and Special Needs Trust, just to name a few. So what a healthcare power of attorney does, it actually authorizes somebody besides yourself the ability to make healthcare decisions for you during your lifetime if you are unable. It also includes designations of end-of-life decisions. Who makes those decisions for you and in what circumstances? Whether you do or do not want a do not resuscitate order, whether you would like to be an organ donor, the disposition of your remains. So if you have a preference of having a funeral, cremation, burial, etc., you can also list those in your healthcare power of attorney. So if you do not have a healthcare power of attorney, generally what happens if somebody needs to make a healthcare decision for you is that that person who wants to make that healthcare decision would need to go to court. So I do have a few of these animations throughout just to keep it a little bit light. But this is generally known as a guardianship of the person court proceeding. So this is where the court actually appoints somebody on your behalf to make healthcare decisions for you, including where you live. It does not end until you either recover from what's causing the disability or when you pass away. You, at that point, would not have an opportunity to make pre-selected designations regarding organ donation, disposition of remains, end-of-life decisions, or a do not resuscitate order. And Illinois law determines who has preference to become your guardian and make these healthcare decisions for you, should you not make these designations yourself during your lifetime. Annual reports to the court are also required of the guardian. The guardian needs to request the court to approve a move or relocation prior to being able to do so. Generally, however, if you have a healthcare power of attorney, you can avoid the entire need for that guardianship of the person court proceeding. If you don't have, the next document is a property, otherwise known as a financial power of attorney. This is where you would nominate somebody and give somebody the ability to make all financial decisions for you during your lifetime if you are unable to do so. You also can make this a future authority, meaning you don't have to give somebody the ability to go out at the moment that you sign the document and give them authority and control over your finances immediately. Usually people like to have these documents drafted in such a way as to provide people with the authority to make these sorts of decisions for them, only in the event that they are unable to do so themselves. It allows that other person to access your finances, deal with Social Security, deal with the IRS, access your bank accounts and pay your bills for your benefit during your lifetime should you be unable to do so. So if you do not have a property power of attorney, what happens is if somebody needs to make a decision for you, in most circumstances, unless you have another account holder or someone with access to the asset that you need to have controlled, is that they would need to go to court. That will be a general theme for all of these documents, is if you don't have them in place and somebody needs to do something, the only alternative is to go to a court of last resort, generally known as probate. So there are two types of probate: guardianships and decedent's estates generally. Those are the two most common by far. This would require a guardianship of the estate court proceeding. This is where one person would be going into court and requesting of the judge to become completely in control of somebody else's finances, which is a major request if you think about it from the judge's perspective. One stranger is going into a court and requesting to become completely in control of another stranger's finances. And because of that, the court places a great deal of emphasis on how that person is appointed, who that person is, the investigation to ensure that that person is the most appropriate guardian of the estate, and then continued oversight of the guardian during the entirety of the guardianship court proceeding. It is an indefinite court case. It can last for many years. It does not end generally until the person suffering from the disability either recovers from what's causing the disability or when they pass away. Illinois law determines who would have preference to become your guardian if you didn't have a pre-selected nomination. The guardian is also required to account to the court annually of every penny that comes in or out of every single one of the disabled person's accounts and provide a detailed report as to why each individual transaction happened. That must be done every year, and it's a way that the court continues to oversee the guardian's decision-making during the guardianship of the estate court proceedings. It is expensive because the guardians of the estate are they are represented by an attorney. And as you might have gathered, it is very burdensome to detail every single transaction of every single day of every single month of every single year and provide that information for an attorney to compile an annual accounting. It is very detailed and it takes a lot of time. There are also other expenses such as a guardian ad litem, which is an independent third party appointed by the court to actually investigate and determine for the court whether the guardian is appropriate and necessary, and that person reports back to the court. There is also another cost of a surety bond, generally an insurance policy. That's usually required by the court and is usually valued at 1.5 times everything in the guardianship of the estate. It acts as a protection for the estate that the person the person appointed as the guardian by the judge won't simply misappropriate the funds or run off with them. So what happens when you pass away? And again, these are general rules, is if somebody has $100,000 of personal property cumulatively, which takes into account financial accounts, automobiles, jewelry, heirlooms, collectible items, if that adds up to $100,000 personally in that person's name, or they have any real estate, then you generally go to court. Again, that's a common theme for all these documents is if you don't have these things set up, the alternative is you go to court to have these things managed by a probate judge. So a brief overview of probate is that it's time consuming. So many people want to open the estate and close the estate. It's not how it works. There are very specific requirements of a probate estate. Generally, I would say it lasts about 1 to 1.5 years. It is expensive. So studies by the AARP suggest that an average probate estate nationally loses between 4 and 10% of its overall value from the probate process, which is absolutely ludicrous to think that 4 and 10% of every days that you've worked for your entire life is going to be spent in an unnecessary probate court process. It's absolutely ridiculous. There are court costs and filing fees from the county, publication in a newspaper. There are, of course, attorney's fees. There can be claims from creditors. And again, you would be required in all likelihood to have a surety bond or an insurance policy valued at 1.5 times everything in the probate estate. The money is generally tied up until the process ends. It does not go to who or where you want it to go to until the process is completed. Creditors are approved or disapproved, or they file claims. Probate estates are public. Every asset is listed out and valued, and it's open to be contested. Creditors also have an ability to file claims against your estate after you pass away, in which they would allege that you owed them money when you passed away. So if you pass away without a will, generally, again, what happens is you go to court if you meet one of those probate thresholds. The state of Illinois would decide who gets your assets. That's known as intestacy. If you are married and you have children when you pass away, the state of Illinois holds that your spouse only gets 50% of your property, and the remaining 50% would go to your children at that time. Again, this is if you do not have a will and you pass away in the state of Illinois as a resident. That's not usually the way that people want their assets distributed. I meet a lot of people to go through this estate planning process with them, and I would say 9% or more easily indicate that they want 100% of their property to go to their surviving spouse. That is not the way that Illinois law holds that your property should be distributed if you pass away with children. The state of Illinois also would decide who's in charge of your estate. State of Illinois decides who will be nominated as a guardian for your minor children. Again, there's all preferences. There'd be, in all likelihood, court proceedings for these things where the judge would determine who would be in charge of these. State of Illinois decides how and when your assets are distributed. Again, that's known as intestacy, which can be problematic to recipients of Social Security, disability, Medicaid, or people receiving VA benefits if they are going to be receiving these things individually. And it can be problematic for a relative who might be going through a divorce, a bankruptcy, or a creditor issue. In any one of these circumstances, it provides unnecessary complications for those types of people who might be receiving these funds. as well as distributing to a relatively young person at 18. Many people that I meet with generally want their anybody around that age to be a bit older before they are receiving any sort of distribution, or at least protected for certain circumstances. So what happens then if you have a will when you pass away? So most people, when they come in, I would say maybe about half, come in and say, I need a will. And then I go through some questions with them, and I'll give them various options. Usually they ask for a will because that's what they've heard about, it's what they've seen on TV and in movies, and it's the most commonly referred to estate planning tool. However, what happens if you have a will when you pass, and only a will when you pass away, and you have $100,000 in your name or real estate, is that you have to go to court. So, which is incredibly frustrating to many people when I tell them that. Despite a common belief, a will is often not the most appropriate document to have assets transferred to your family or other individuals or charities. A will is simply a roadmap for a judge. So as I indicated earlier, if you pass away without a will, Illinois law has something known as intestacy, as do most states, where there's defaults of what happens with somebody's property if they pass away without having pre-selected designations in a will or something similar to that. Illinois law would determine who gets what. A will replaces those Illinois defaults. It simply acts as a roadmap for a judge. You would replace the Illinois defaults of who's in charge and who gets what, but that's basically all it does. You still have to go through the probate court in all likelihood. It directs the court how your assets are to be distributed, and it directs the court who's to be appointed as your state representative. Despite me saying those things about a will, it is still very important, and it often acts as a supplement to other estate planning tools. However, it's still important if you have any minor children in your will to appoint guardians and preferably successor guardians of any minor children or incapacitated children that you might have. So some of the common misunderstandings that people have about estate planning is that they have a will so that their family will not need to go through the hassle of the probate court after they pass away, or that they're not rich so they do not need a trust. A trust often has a connotation of extreme wealth, of generational wealth. It's simply not true, and I wish that connotation didn't exist, because the best way to avoid having to go to probate court after you pass away is to have a trust. Trusts avoid probate court if drafted and funded properly. If that is done, the assets would not be frozen. There would be no need to wait the 12 to 16 months in a probate case for your family to obtain the property that you wish for them to receive. A trust is not a public document. There's no need to pay any attorney's fees for court after you passed away. There's no need to pay for an insurance policy or a surety bond for that person to act as the estate representative. There's no need to pay court costs with the trust because there will be no court case. There's no need to pay a newspaper to publish notice of the estate opening, which is generally done in probate cases to limit the period of time of creditors to file claims against your estate to 6 months rather than 2 years. And it's an agreement for you and or your spouse's property during your lives and after your death. Trusts are extremely flexible and can be changed when needed, so nothing is set in stone. So briefly, an overview of wills and trusts again are: wills do not avoid probate court. Trusts generally can avoid court. A will is a roadmap for a judge about how assets should be distributed. Trusts are more complex and powerful. Wills have no effect until death. Trusts are private documents. Wills are public documents. Trusts also provide those inheriting your property with significant additional benefits. Very briefly, I want to touch on these. Additional benefits of the trust are that there are no unnecessary costs after your death. The family can completely handle the distribution of your property without any unnecessary court involvement or attorneys. Provides creditor protection for beneficiaries and can provide creditor protection against potential future ex-spouses of the beneficiaries that you want to inherit from your trust. It can provide protections to vulnerable beneficiaries, such as those receiving Social Security disability, VA benefits, Medicaid benefits, or those who might be minors, so disabled beneficiaries. There are many, many different types of trusts, and it would take far longer than the time that I have allotted to go through each one of them. So there are testamentary trust, special needs trust, self-settled trust, third-party trust, irrevocable trust, revocable trust, spendthrift trust, life insurance trust. There are all sorts of options available to people. Now, most people, generally, absent specialized circumstances, choose to have a revocable trust, meaning that they can get rid of the documents or change them at any time that they would need to. It's very easy to bring your trust and all of the documents that I referenced today into compliance with changes that inevitably happen in your lifetime. So the healthcare power of attorney, the property power of attorney, the HIPAA authorization, wills, and trusts can all be modified during your lifetime so long as you're mentally able to do so. This provides you an ability to change with the changing needs of your families and the beneficiaries, your personal goals, inevitable life changes, births, deaths, divorces, things of that nature, and then things that you might not be as aware of, such as legal changes or tax changes. And I was going to this morning present with a financial advisor, Amber Luzak of Edward Jones. We work together and often work together to prepare a more well-rounded estate, not only from a legal perspective, but otherwise from a financial perspective. And much of the information that I have about some of the additional materials will be coming with her involvement. She was unable to be here today, but I'm still going to present this in such a way as to provide you with an overview of both sides. So as important as establishing your estate plan is monitoring, updating, and reviewing those plans. Oftentimes, some changes that would be required to be made in these documents are very easy to notice. That you can notice because it's your life and you can see and observe what's happening. Family changes, births, deaths, illnesses, adoptions, divorces, property changes if you buy or sell a new home, if you receive an inheritance, if your asset levels go up or if they go down, or if you simply have changes as to your wishes. Who you want to make these decisions for you and in what circumstances, who you want to inherit your property from you. Those are all types of things that are easily noticed by you. However, there are some types of changes that are very difficult to notice because it's not your job to notice them. So it's very important to work with an attorney, a financial advisor, people like CPAs, insurance brokers, and the great organization of Elderwerks, who provides incredible benefits to seniors. So it's important to be aware of certain changes in the laws and the tax code, as these can have a major impact on your estate plan and beneficiaries. However, again, it's not your job to be aware of those things. It's people like myself, financial advisors and CPAs, that need to be aware of these changes. And just this year, due to many different circumstances, there have been significant changes that can affect your estate plan, which I want to go over now. So this is a brief overview of the estate planning process in very broad strokes. Generally, you meet with an attorney, you review documents, or you set up your wishes, design a plan, get the documents ready. You start transferring things to your trust, and then you definitely want to monitor or provide an annual review of some kind, which I will get to in a minute as to what that might look like. But it's always a good idea to make sure that these documents are not only set up at the time that you draft them, but at all times moving forward. And that's why it is important for attorneys and financial planners and CPAs or insurance agents or people like Elderwerks to work together as a team for your benefit. So one of the major changes that have occurred very recently due to the COVID-19 pandemic is the unique and important change that the state of Illinois and many other states have taken with regards to remote witnessing and notarization. So many people might not be aware of this, but just a few months ago, on March 26, 2020, the state of Illinois has authorized remote witnessing and notarization of documents, explicitly including estate planning documents. So what that means is that in the comfort of your home, the estate planning documents can be delivered to you. They can be mailed to you or emailed to you. They can be reviewed with you by your attorney. You can review them at your leisure prior to meeting with the attorney. Then, once you're ready, if no other changes would need to be made to those documents, you can sign those documents in the comfort of your home without ever leaving, and they will be legal. They will be legally authorized because the witnesses and And notaries will be available via video conference, just like this, like Zoom or GoToMeeting. There are certain requirements of that video conference, which the attorneys would take care of and enable you to make those types of documents valid at your home. So the governor authorization, again, explicitly said that this enables Illinois residents to make critical personal and business decisions and finalize planning documents that often require the services of a notary public or a witness. The state of Illinois, as I'm sure everyone here is aware, is trying the best they can, without getting too much into that. The idea is to keep people at home as much as you possibly can, and don't unnecessarily expose them to anybody else that they wouldn't have to. So seniors, people who might have underlying health conditions, it would be very important to get these documents in place, especially in a pandemic. So this authorizes you to have these documents prepared at your home without any unnecessary risk or exposure. And that the attorneys would certainly take care of setting up the witnesses and the notaries. Another very important change that happened this year that many people are not aware of is the passing of a federal law known as the SECURE Act. SECURE is an acronym for Setting Every Community Up for Retirement. It's a comprehensive retirement and savings law that took effect on January 1st of this year.
So where I was is that currently the United States has passed sweeping legislation known as the SECURE Act. And just as an aside, I will make this presentation entirely available to anybody that requests it. So if you would like this information, I'm happy to provide it to anybody. Again, I apologize for this inconvenience. You can also call me with any questions at any time. However, what the SECURE Act is it is a sweeping, comprehensive law changing retirement and savings for Americans. So what it does is it has some benefits and it also has some major trade-offs. One of the benefits it has is that it has expanded retirement for part-time workers. If you've worked more than 500 hours per year for 3 or more consecutive years, you must be allowed to participate in your employer's 401k program.
Sincerely apologize. What the SECURE Act also does is it changes required minimum distribution ages. So before the SECURE Act, qualified retirement account owners had to begin RMDs, or required minimum distributions, at age 70 and a half. After the SECURE Act, however, qualified retirement account owners had to begin taking required minimum distributions at age 72, subject to some people being grandfathered into the previous age. It also eliminated the age limit for traditional IRA contributions. So before the SECURE Act, you could not contribute to an IRA in the year that you turned 70 and a half or afterward. After the SECURE Act, individuals can contribute to an IRA with no age restrictions. Very significantly, it has eliminated what was known as a stretch out provision for non-spouse beneficiaries. This is a huge impact on many people's plans and the assets for which they intend to pass to future generations. Before the SECURE Act, individual beneficiaries had the option to stretch out required distributions from an inherited qualified account over the course of their lifetime. This provided an incredible benefit. It allowed for, let's say, somebody who might be 80 years old, passing property on to somebody who might be 55 years old. That 55-year-old then had the opportunity as an inherited qualified account to stretch out the distributions from that qualified account over the course of their calculated lifetime, which means they could take the money out over 20, 30, 40 or more years. Why this is so beneficial is it allows for smaller distributions over many years, much more much more tax-deferred growth. This provided for a continuously compounding benefit to future generations. After the SECURE Act, however, distributions for most non-spouse beneficiaries are required to be distributed over a 10-year period. And again, this is why it's so important to meet with attorneys regularly, or financial advisors, or your team that you put together, to ensure that you're aware of these types of things and change your plan as needed, because this has an incredible impact on everybody's plan who has retirement accounts. This act, the Secure Act, was passed with bipartisan support. And when you get bipartisan support, there's usually a reason for that. One of the major reasons I believe that this act passed is because it's called revenue enhancing. Another way to describe revenue enhancing is called a tax increase. The Secure Act, because of the elimination of the stretch out provision, is estimated to generate an additional $15.7 billion because it's eliminating those benefits to future generations. So this is a very simplified graph of an example from Forbes showing you what a stretched provision could do or offer to future generations, rather than with the dotted line, what the elimination of the stretch out provision is estimated to do for people and their families. So often it's not hard to see the difference in these figures. So your spouse, however, can still receive the distributions without having to stretch them out. That hasn't changed. But those who want to leave property to their children or future generations have been significantly impacted from the elimination of the stretch out provision. Other impacts of the Secure Act that people should be aware of, but oftentimes are not, because again, it's not their job to be aware of these things, is that there are now penalty-free distributions for birth or adoptions. There are expansions of the 529 plan to things besides college. So 529 are also often college saving plans. You also can now take those funds out and use them for registered apprenticeships rather than going to a college, or repaying certain student loan payments. Another change recently that has made the news, and I'm sure many of you have heard of, is something that's known as the CARES Act. Again, it's an acronym. This one stands for the Coronavirus Aid, Relief, and Economic Security Act. It is a sweeping piece of legislation signed into law on March 27th of this year. It has had many, of course, highly publicized provisions: the Paycheck Protection Program, SBA loans, loan forgiveness, economic injury disaster loans, and unemployment benefits. These have been on the news since March 27th, and they're still going through additional negotiations for COVID-19 relief. However, it does have some impact and less publicized impacts on people's estate plans and their financial plans. So there is retirement plan relief. So the CARES Act has authorized significant relief associated with retirement accounts. Specifically, the CARES Act has authorized up to $100,000 in withdrawals from retirement plans, which are then not subject to tax withholding or early distribution penalty. It is also eligible for those withdrawals to spread the taxation over a 3-year period rather than being hit with all of that in 1 year. Now, whether that's a good idea to take money out of retirement is a completely separate issue that should be discussed with, between yourself and your family and the team that you put together. But it does provide people with an ability and more flexibility to do things. It increases plan loan limits, it delays plan loan repayments, and it waives required minimum distributions for certain retirement plans for this year. So these are all very important things to be aware of, but are oftentimes far less publicized than things like SBA loans and payroll protection. Additional important, but again, less publicized provisions of the CARES Act include Medicare payment provisions, Medicare sequestration relief, pension funding relief, business interest expense deductions, foreclosure and eviction forbearance, tax-free employer student loan repayments, and student loan payment temporary forbearance. It is a gigantic piece of legislation that I'm sure many of you have heard of. However, there are all sorts of benefits or options to people that they might not be aware of. So very briefly, and again, I know I flew through this information. We had a bit of a technical difficulty in the middle of it that kind of disjointed the flow of everything. But I will make this presentation. Obviously, it's being recorded, but if anybody would like these slides, I'm happy to share them with you. My contact information is listed on this presentation. It should be in the chat box as well. So Additionally, however, with my firm, Bruning and Associates, we do have free consultations. So again, I flew through this information that Trust and Estates is a course in law school that people take over one or multiple semesters. So it's impossible to hit every single question that somebody might have or every single circumstance. However, if you do have questions or want to discuss something or you have a circumstance that you would like to bounce off somebody, please feel free to contact me. I'm happy to discuss those with you. We have free consultations, so you would be charged absolutely nothing to go through those specific questions that you might have. Please don't hesitate to contact us. We do have offices in Crystal Lake, in Schaumburg, and in downtown Chicago. Although I do live in Crystal Lake, I am the person in our firm who handles most of the estate planning and probate work and travel to all of the offices. So if one of the offices is more convenient for you or a family member or a friend or anybody, I'd be happy to travel to them. We are also offering telephonic and video conferencing currently for consultations. So if you don't want to leave your home, please. I have a 4-week-old. I don't mind doing everything remotely here to limit exposure. I'm happy to do it however you guys would like to do. We do offer flat fees for all of our estate planning services, which I think is a consumer-friendly practice to have because there's no guessing as to how long something might take or how many billable hours there might be. We generally want to be as transparent, upfront, and honest with everybody about what it would cost, and then you would have the option of saying, yes, I want to proceed, or no, I would not want to proceed. We also prepare additional documents such as the quitclaim deeds to transfer your property to your trust. Once you establish a trust, it is equally, if not more important, to fund that trust. And what I mean by that is to transfer property from your individual capacity to your trust. A trust only controls and manages things that are owned by the trust. So how the trust becomes an owner of the property is by legally transferring ownership of assets to your trust. Bank accounts, you can make trust the beneficiaries of life insurance policies, and importantly, you want to put your home or any residence that you have or any real property you have into your trust. You can also put business interests into trust. You just want to put as much as you can into your trust so that you get the protections and benefits of that trust. We would help with and provide guidance if necessary as to how to do those types of things. Because if you do not put anything into your trust, you have a trust document that controls nothing. You are risking having to go to probate despite having this set up because it was not funded properly, which is equally as important. Yes, so trusts are only effective if the assets are funded to the trust, which we can help with. And we want to meet with you annually. And it's important to meet with your attorney annually, or your CPA, or someone like Elderwerks, or your financial advisor, because of the changes that inevitably happen with your family, your property, your wishes, the taxes, or the laws. Again, obviously, some of those things you will be aware of the changes and the need to change certain things in your estate plan. Things like the tax changes and the legal changes that we went over today, you probably will not be aware of. So that's why it's important to meet with you to ensure that not only is your estate plan structured properly at the moment that you sign it, but at all points moving forward, and to ensure that your assets are properly within your trust. Because
Jonathan, we have 2 questions. Can I go ahead and interrupt you?
Oh, yes, absolutely. I'm sorry.
That's okay. We have to finish up in 4 minutes.
Yep.
So the first question was, do we still need a notary for remote signature?
Yes, anything that would require a notary still requires a notary. However, the notaries can also handle remote notarizations. So you can have a notary on a video conference like this, and it would still be legally valid. But if a document needs a notary, you still have to have it notarized.
Excellent. And the next question is, does the 10-year distribution requirement apply to IRAs inherited before 2020?
Great question. No, it does not. It's moving forward.
Excellent. Those are the 2 questions. One was, where are the sessions? All of our classes today are available at elderwerks.org under news and events, senior fair page, and then the classes. They're all there. Let me make sure there's no other questions here. Let me check the chat. Looks like I got all the questions. If there's any other questions, we have a few more minutes. Jonathan's live. He's happy to answer any questions on the Q&A or in the chat box. Good. Thanks so much for coming on, Jonathan. We appreciate it.